Hello and welcome back to the channel. My name is attorney Stanley Helinski and I've been a practicing lawyer since the year 2000. Through these years, I've been a trial lawyer, an appellate lawyer, a family law lawyer, and a corporate lawyer, among other areas of practice. Today is a very special episode as I'm going to give you a complete guide for when you are pulled over by the police under the suspicion of drinking and driving. The information in this video is long and detailed, but at the same time, a DWI and OUI case can ruin your life. It may cost you your job, your career, your marriage, and so much more. If you're pulled over by the police for suspicion of driving while impaired by alcohol, there's a very high likelihood that you're going to be arrested and charged. Follow this video, and it'll give you the absolute best chance of getting through it. And it'll put you in a perfect position when you actually get to a lawyer. We can only do so much as lawyers. Even the best lawyers are bound by the facts. So if you avoid some of the recommendations in this episode, it'll be that much easier to get you out of the charges. People are way overcharged for this offense, and many are charged when they should not be. I'd suggest that there's really no downside for a police officer to arrest you if there's even a hint of alcohol involved. If they smell alcohol and let you go, it'll cost that police officer his career. If after he or she lets you go, you drive a mile down the road and get into an accident, they're going to find out that you had just been pulled over and let go by this police officer, and it's going to cost that individual their job. It's sort of all about self-preservation. And if you jump behind the wheel after you've had even a couple drinks, you're leaving your life to chance. And the police don't discriminate. The nicer the car, the more likely you'll be pulled over. So you may want to skip around this video, but I suggest that it's a good idea to take notes of every bit of this. Why should you listen to me? I've tried probably 50 or so DWI, OUI, jury, and bench trials in my career. I've lost a total of 3. Each of those involved very serious crashes that were caused by the client. These accident cases are winnable, but when there's alcohol combined with a very bad crash, becomes very hard for a jury to let you go. So you need to follow these rules even closer if you're coming off an accident. Every single other case I've tried, the client has been acquitted of this charge. Even cases where the blood alcohol was as high as 0.11, where 0.08 is the presumptive legal limit, I was able to get the acquittal. DWI, OUI cases are the easiest cases to win. Don't stop watching because I said that. The conviction rate is still around 80%. The reason it's so easy to win these cases, it's very hard to prove that a defendant was impaired by alcohol rather than the 1,000 other impairments and distractions that everyday drivers have. Any reasonable prosecutor will agree with that statement, and I give them a lot of respect for the efforts that they go through to try these cases. They're difficult cases for a prosecutor to try. Let me first explain what the government has to prove in these cases. A prosecutor must prove beyond reasonable doubt that the defendant was impaired by alcohol when he or she was driving a vehicle on any public way. That's it. And as I'm going to show you in this video, the way they prove that is through evidence that the defendant handed right over to the police voluntarily and didn't have to. I can say that almost every conviction for drunk driving is achieved through the introduction of evidence that the defendant, him or herself, gave to the police that he or she absolutely did not need to give and likely should not have given them. These people not only don't know that they may refuse, but the police are trained to trick people into thinking that by consenting to various tests, it will help prove that they're not drunk or impaired by alcohol and that they'll be let go. Since most people, quote, feel okay after having a couple drinks, that all sounds pretty good. What most people don't know is that when you get pulled over and there's the tiniest belief that you've been drinking, most of the time the decision to arrest you has already been made. First, people always ask me if they should take the breathalyzer. To be clear, submitting to a breathalyzer is completely optional. You do not need to take one. The hook is, and the hook that police are happy to throw in your face as a threat, is that by refusing to take the breathalyzer, you'll be charged with a separate crime or you'll lose your license for the refusal. It's absolutely a personal choice as to whether or not you should take it. I advise people never to take the breathalyzer, but I'm going to explain my rationale for my advice. Also, at least in some states, if you beat the case before your suspension is up from refusing to take the breathalyzer, you should be able to get your license back right away without serving the entire suspension period. There are some exceptions, but that's the law. On second offense cases where there's a 3-year suspension, that really does matter. The first problem with the breathalyzer has to do with false positives. There are certain foods and products like mouthwash, toothpaste, mints, and a host of other things that trick the machine into believing that you have alcohol in your system. Let me tell you something that should horrify you and that I've actually seen performed. If you, without touching a drink, wash your mouth out with mouthwash, regular everyday mouthwash, then wait a full 15 minutes, putting nothing in your mouth the entire waiting period, and then take the breathalyzer, your blood alcohol will be 0.08 or above. That's the actual legal limit. And we don't even know all of the products that will have that interaction with the machine. Gum, mints, things you'd never think twice about. The problem is this. By agreeing to take the breathalyzer, you are rolling the dice as to whether you put something in your mouth that is going to set the machine off. That alone could seal your fate. Just because you know you haven't taken a sip of alcohol doesn't mean you'll pass the breathalyzer. So that's one. You should know that there are actually 2 times when you may be asked to take the breathalyzer. One is before you get arrested and another is after. There's 2 separate times. Before you get arrested, when you're still on the roadside, you may be asked to take a PBT, or preliminary breath test. The second time you'll definitely be asked to take a test is at the police station, and that is with the Draeger Model 9510. The roadside device, the PBTs, are largely inadmissible in courts because they're just scientifically unreliable. And because of that, a lot of police departments have stopped using them altogether. They have the same problem as the Draegers, the false positive, but there's no penalty for refusing the PBTs other than getting the cop mad at you who's going to arrest you anyway. So I shouldn't have to say there's no point into blowing into one of the PBTs, the roadside test. The primary reason why I believe you should not take the Draeger breathalyzer test, the one at the station, is that you're giving evidence directly to the people who want to prosecute you. What's that saying? Don't give your enemies the means of your own destruction? Well, that's exactly what you're doing. You're handing evidence over to the government that they otherwise would not have, that they will definitely use against you. Imagine if the officer asked you this. Hi, defendant that we just arrested. We don't think we have enough evidence to get you convicted, so would you agree to let us get more evidence from you? You would need to volunteer to give it to us. There's no difference between the two. That's exactly what you're doing. Now, a lot of people think that they didn't drink that much, so this is a really good opportunity to clear themselves. The officer is literally telling them specifically while acting like he or she's their best friend. Well, it's not that easy. Initially, the people looking to prosecute you are the ones analyzing the evidence. It's literally in their hands. Think about this. The police arrest you, tow your car, on the basis that they believe you're impaired by alcohol. Well, what happens if you take the test and the reading is truly extremely low? And this officer has arrested a number of people in the past over the last year who hadn't been drinking either. I'm just not someone trusting enough to put that situation in the hands of people who realize they've just screwed up. There's all sorts of ways to keep you on the hook, including claiming that you didn't blow enough air, which goes down as a refusal. Another really good reason not to take the station breathalyzer test is that if you do take the breathalyzer test and actually pass the test, meaning that your reading is below 0.08, there's still a good chance that you'll be charged anyway with the lower number. So just as you thought you're not drunken that much at all, you took the breathalyzer because you knew you were fine, and that the breathalyzer would come back below the legal limit. You did below the legal limit, and you're still being charged with drunk driving. The government will argue that because your blood alcohol was 0.06 at the police station, that it was likely that your blood alcohol was higher at 0.08 when you were driving, since you had not drunken any alcohol in an hour or so, and that your blood alcohol must have steadily been dropping on your way from the roadway. They'll argue that you should be convicted because your BAC was likely 0.08 when you were operating a motor vehicle. There are significant evidentiary issues with this kind of evidence. That discussion is beyond the scope of this video, but the point is, even if you pass, you lose. That's a second reason to refuse to consent to this test. A third reason you don't take the breath test has to do with what we call the Pierre rule, derived from Commonwealth versus Pierre 72 Mass Appellate Court 230, 2008 case. The issue here is that if you burp or if you cough, After you've consumed alcohol, but before you take the breath test, you push some fresh undigested alcohol back up into your mouth from your throat to your stomach. This is undigested, so it's in your bloodstream. We call this mouth alcohol, and it's a known defect in the machine. Because of this unavoidable reality, the cop who's operating the breathalyzer is required to observe you for a period of 50 minutes before administering the breath test to be sure that you don't burp or cough. And if you do, the 15-minute period restarts. This is called the Pierre rule. It's a good rule and it's consistent with the technology. However, in real life, the police don't really watch you very closely. The appeals courts over time and over the years have chipped away at the Pierre rule because they have all this station video without the cop sitting and watching the defendant, though it was clear from the video that the defendant hadn't burped or coughed. So the court started to say that the cop doesn't really need to sit there and watch you, that you may be, quote, observed while you're being booked or while the officer is doing something else. So it's entirely possible that you burp or cough, nobody sees it, mouth alcohol is pushed back up into your mouth, and you get this artificially high reading, also called a false positive. So what can you do about that? Absolutely nothing. The results will be viewed in the exact same manner as with any other test. Yet, your blood alcohol actually differs from the test results. So there's another scenario where your blood alcohol is below the legal limit, but your test results have you over it. If that isn't enough, there's another whole issue relating to the calibration of these machines. Some years ago now, there was litigation over alleged improper calibration of the machines. The Draeger machines need to be calibrated against a known sample before they're used. Not only were there problems with the calibration, as was alleged in the lawsuit, but the government agency knew of it, and some people withheld certain evidence in the litigation. Well, the judge overseeing the litigation excluded tens of thousands of breathalyzer results because of this. It's really only been a couple of years since we've had actual breath tests come back into evidence in cases. During that time, I've had a number of cases where the breath tests were above the legal limit, but the jury never heard about it due to this litigation, and the defendant was acquitted. The point is, humans who have no idea how these machines work had been calibrating them. So the question is, do you want to take a chance over any of these issues, that you'll benefit from any of these issues? I personally wouldn't want to. So that gives you likely more information than you've ever hoped to know about breathalyzers. I'm hoping you're not watching this on the side of the road somewhere waiting for the police to come to your window, but if you are, you know what to do. Now, that's not close to all there is to this. Breathalyzers are just a tiny piece. There were plenty of convictions over those years where we had no breath tests at all when they were thrown out, for reasons that I'm going to explain now. Close to 100% of all convictions involve this second type of evidence. They're called the roadside tests. Think of that person standing on the side of the road with their head back and their eyes closed, trying to touch their finger to their nose. We don't really do that exact test anymore, but that's exactly what we're talking about here, roadside tests. I would venture a guess to say that nearly every single conviction for OUI, DWI was based at least in part on this kind of evidence. So you should listen. There's nothing to memorize here about how to take the test. The takeaway is that these tests are 100% optional, just like the breath test. They call these tests field sobriety tests. Well, they aren't tests because they're not pass-fail exercises. The police will admit that on the stand. And they're not assessing sobriety, they're assessing impairment. But you absolutely do not have to participate in these assessments, and you should really never do that because they're so incredibly subjective that no matter how you do on these tests, they'll never be exculpatory, meaning that they'll never provide evidence that you are not impaired as a true double negative. They will always provide evidence of impairment. It's a true fool's errand. If a cop thinks you've been drinking, he or she will find a way to say that you performed in a substandard manner on these tests. And without body cam, it's pretty much his or her word that's going to carry the day. I had a case where the cop thought he was failing the defendant on one of these tests, but when I went through the results with him on the stand in comparison with the National Highway and Traffic Safety Administration's training manual, which is the Bible on how to perform these tests, my client actually passed each one. Well, the cop thought he was sinking the defendant. It was a, relatively new cop. But the takeaway here is that even though that was a 5-minute not guilty in my case, my client still had to go through the arrest, the initial loss of his license. He had to pay me. He had to come back to court once a month for an entire year. He had to take work off each time he did that, not to mention the incredible stress and the fear of losing his job. Don't agree to participate in these exercises. They're a fool's errand. You're still going to be charged, but you're going to be charged anyway. And now the government has that much less evidence to demonstrate impairment or to give the jury something to think about. That's not it to this, though. You have to do this next advice in conjunction with the refusal, or the decision to refuse will backfire on you. You can't just stand there and say, I refuse. You have to give them a reason, because the jury is going to hear that reason, and the prosecutor is going to paint the picture that you knew that you were drunk, so you didn't want to take the test. Say you have trouble balancing, you're too tired, you're sick, you have a headache, you're too nervous, you're too distracted being on the side of the road. Whatever reasonable basis you have for not standing on the side of the road with cars whizzing by while you try to stand on one leg for 30 seconds. Whatever is your truth, you give that reason or reasons to the cop and you stick to your guns. The cops, especially state cops, will try to push you to take these tests. They make it seem like it's a personal insult for you to refuse them. They'll tell you you need to exculpate yourself and you need to take these tests to free yourself. They'll say that you're going to be arrested and lose your license if you don't take them. These people are pure bullies and they're not your friend. They're going to try to ruin a good chunk of your life. Absolutely hold your ground. Be very polite and say, I'm very sorry, sir, but I decline to participate, and whatever this is, and give whatever your reasons are. You'll be arrested, but unlike the breathalyzer refusal that's going to come next, you'll not be penalized or charged with a different crime for refusing to take the roadside test. And being arrested is far better than being convicted 100% of the time. You're going to get arrested anyway. If they have you out of your car under suspicion of drinking and driving, then in all likelihood you're going in. Now, I won't even get into how riddled with problems the administration of these assessments have on determining impairment, because you're not even going to take them. In theory, the assessments make sense and are a good assessment of impairment. The problem is that they're unscientific, because there are so many other factors that affect the test, like flashing lights, bad shoes, so many other issues. And the officer administering the test doesn't keep these external factors out, so the test is really unreliable. Politely and with good reason, refuse. And since you are now talking to the cop, you need to be warned of the following. Shut up. Don't tell the cop evidence that can be used against you, like you've only had 2 drinks. There's a silly clause in the U.S. Constitution that says you don't need to give evidence against yourself in a criminal investigation. Well, getting pulled over for DWI and OUI is a criminal investigation. Don't tell the cop that you drank any alcohol. You don't need to answer any of those questions. Just so you know, everyone says that they only had 2 drinks. Literally everyone. People think that if they say that they've only had 2 drinks, the cop will let them go. It's just not going to happen. And you've now just admitted to drinking alcohol before you drove the car. Piece of evidence the government didn't have before you said it, leaving only the question of your credibility as to how many drinks you actually had. You do not have to answer questions that may incriminate you. Politely decline to answer. I'm almost done with this critical stuff, but you cannot ignore the next one, that there is actual video being recorded all the time in the police station, and I can get a copy of that. Remember those cases I told you about where there was a failed breathalyzer test and I still got an acquittal? It's because of the booking video that I got my hands on. Comparison of the video to the cop's description of the defendant at the scene were highly incompatible. That ruins the cop's credibility while establishing that you don't look drunk in the video. So what can you do about that? It's easy. When you get to the police station, stand still. Don't sway, don't fidget. If you can keep from doing that, just stand still. When you get to the police station, try to imagine 8 jurors, a judge, 2 court officers, a lawyer, a prosecutor, and a couple cops all watching you at that very moment, because that's exactly what's going to eventually happen. If you somehow get bullied into taking the breath test, I can show the video to the jury and argue that your depiction on the video is inconsistent with the breath results, and that 0.8 is only a presumption. It's not conclusive, and that everyone has different tolerances to alcohol. The government must prove impairment, not blood alcohol level. So I'm done. There's so much more to this, but those are the main ones. For those who can stick around, let's review. It's your choice to any of these, but I usually advise as to the following. Pull your car over immediately and stop without anything out of the ordinary. Don't tell the officer anything, certainly not admitting that you drank any alcohol. Don't take field sobriety tests. Don't take a preliminary breath test. Stand still when you get to the police station. Speak as little as possible. Don't sway or wobble or fidget, and don't submit to the breath test. You come to a lawyer with only that evidence, and you'll be in the absolute best position to beat your charges as you possibly could be. These cases have the lowest conviction rate out there. I don't plead any of these cases. I really don't plead most cases, but many, many lawyers will push you to plead these. Be sure to speak to a lawyer who is open to trying the case before you make any decisions, and ask specifically how he or she will try it. Ask for a sample cross-examination after he or she reads your police report. So I hope this video was helpful. DWI-OUI is scary. It's often the first time you've ever been arrested. It seems like you want to be marched off to the death chamber when it happens. It'll be okay. Getting arrested is really the worst part of all of this. These are very beatable cases, and in many situations must be beat because your job depends on it. Your HR department will likely be monitoring your case until it's over. So let me know in the comments if you've ever been pulled over for DWI or OUI and whether you've experienced any of what I've talked about. This video helps me as much as it helps you. If everyone came to me after following what's been said in this video, I'd likely be able to guarantee you some favorable result, which I rarely do. I don't guarantee results because there are too many unknowns in this process. As always, the information in this video is general legal commentary. It's not intended to be analysis of your specific case. You should always have your case reviewed by a competent attorney. This is tough stuff. It needs to be looked at by an experienced attorney. This is a very specialized area of the law. Absolutely hire someone who you know specializes in this area. Thank you for watching. If you enjoyed this video, please like the video. If you're into legal videos like this and legal issues in general, go ahead and subscribe to the channel. It's free to do and helps the channel. Leave me a comment if there's a topic that you would like for me to discuss. If you want to know how to beat restraining orders, watch this video next.